This voice thread is going to be an introduction and overview to freedom of speech, or perhaps more accurately, freedom of expression. So we're now moving into the second part of the First Amendment that we will be delving into. And I just want to take a moment to revisit the text of the First Amendment. So again, it's very short and seemingly straightforward. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. We're going to be focusing on the part that on the slide is listed in bold, abridging the freedom of speech, right? So as we've seen in the religion cases, this Congress shall make no law language isn't exactly accurate, right? So first we have this very strong prohibition, but then we begin to see exceptions being made. And we're going to see the same thing here in the freedom of speech cases. The United States has broader free speech protections than most comparable liberal democracies. Now, that said, there are some limits to our freedom of expression. I'm going to begin with a couple of cases, and I'm going to ask you to reflect on whether or not you think these are First Amendment issues, or whether they should be First Amendment issues, even if they aren't. These cases are also listed on the discussion board, and I urge you to comment there as well. So we're going to begin with James Damore. So Damore recently settled a lawsuit with Google. He was fired from his job as a Google engineer. And the reason for this was that he published this lengthy and public memo, one might call it even a manifesto, wherein he attributed differences in performance, promotion, and hiring to natural or biological differences between genders, right? So in this memo that he published, again, very publicly, he paints broad generalizations about both males and females, then drawing, again, these very broad and forceful generalizations about their job performance. In the same memo, he alleges a culture of repression, right, wherein opinions like his cannot be freely expressed. Well, Google fired Damore as a result of the publication of this memo. So is this a First Amendment issue? Why or why not? More broadly, should we consider it a First Amendment issue? Again, why or why not? Here we have another freedom of speech question. This one deals with Milo Yiannopoulos. You're probably all familiar with Yiannopoulos. If you aren't, take a moment and Google him. Right, so in 2016 was probably the height of Yiannopoulos' notoriety. He's fairly irrelevant now. But in 2016, he got a lot of public attention because Twitter permanently suspended his account. Yiannopoulos had led a really nasty campaign, right, of racist and misogynistic insults or cyberbullying against actress Leslie Jones using Twitter. So when Twitter permanently suspended his account, Yiannopoulos released a public statement saying, and I quote, "They made a very dumb decision right before I had the eyes of the world media on me. I think they're going to come to regret it. Anyone who believes in free speech was sent a very powerful message today, which is that you're not welcome on Twitter." So is this a First Amendment issue? Obviously, Twitter isn't a government entity, right? And so generally, we only see constitutional questions arise when you have a government entity taking some kind of action against a citizen, or an action that infringes on a citizen's constitutional rights. But I want to kind of broaden this question. So if your initial response is no, because Twitter isn't the government, you are correct. But it's a little bit more complicated than that. We're going to touch later on the idea of a public forum. A public forum is a space in which traditionally people have expressed themselves freely on issues that are fundamental to liberty, right? So issues like politics, religion, art, literature, that sort of thing. And as we'll discuss later, in certain kinds of public forums, the government extends greater First Amendment freedoms, right? Even if the government didn't itself make the forum. So there's an argument to be made for treating Twitter as a public forum. We'll return to that when we get to public forums, but I just want to raise the question again. Should this be a First Amendment issue? Obviously, this is a freedom of speech issue. And here we have our third question. So again, this is on the discussion board under initial intuitions. So you should go on there and comment on whether or not you think it is a First Amendment issue, and then again, whether you think it should be, and why. So this third case deals with a former Georgia police officer by the name of Greg Abbott. During a traffic stop, he told the driver that he'd pulled over, who was a white woman, she had expressed fear at reaching for her wallet, fear that she would be mistaken for reaching for a weapon and shot. His response was, and I quote, "But you're not black. Remember, we only kill black people. Yeah, we only shoot black people, right?" That exchange was recorded. And subsequently, Abbott was fired from his position as a Georgia police officer. So he was a government employee. He was speaking in his capacity as a police officer. But Abbott is also a citizen. So is this a First Amendment issue? Was his firing a violation of his freedom of speech? Or should we consider this a violation of his freedom of speech? If so, why? If not, why not? As I discussed at the very beginning of this class, we see the Constitution divided into different kinds of rights. So we can think of them as individual rights versus group rights. When we get to civil rights, we're going to look more at rights that people hold as members of groups. But again, under the First Amendment, generally we see these interpreted as being rights of individuals. This is going to be important when we talk about freedom of speech, because this reasoning is part of why there is, for instance, no hate speech exception under the First Amendment. That used to be, just as a brief preview, that used to be considered a quote-unquote group libel, right? So libeling a whole group of people. And that category is no longer recognized as existing, right? There's no such thing, according to the Supreme Court, as group libel. So what we're going to be seeing are individual rights, right? So when we look at freedom of expression, these are individual rights that are enforceable against government action only. Like most of the Bill of Rights, this used to only apply to the federal level. It is now incorporated, right? Which is to say it now has been applied at a subnational level, meaning it applies to the states, to municipal governments, etc. And it was incorporated through Gitlow versus New York, one of the cases in your first set of readings. As I mentioned, there is a fairly limited number of categories of exception to First Amendment freedoms. The first one that we're going to look at in this module is advocacy of illegal action. Now, today, advocacy of illegal action is no longer a category of exception. Rather, we refer to it as incitement. What's the difference between these things? Well, we'll see this emerging through the cases that we look at in this module. But the sort of like shorthand answer to that is the immediacy and likelihood of the threat, right? So advocacy is merely discussion. But if we go back to the beginning of the country, advocacy of illegal action wasn't necessarily a category of speech that was protected, right? So your book discusses the Sedition Act of 1798. This is sort of notorious because it actually was never challenged under the First Amendment, even though it did criminalize many forms of criticizing the government. Imagine that, right? If today you could be punished by the state for criticizing the government, how would that undercut the working of a democracy, right? So what are the kinds of like public purposes for protecting this? So what we're going to look at initially is how the standard for incitement actually developed. So we're going to ask some questions about where the line should be drawn, right? So maybe we don't want to punish people for criticizing the government, but what if they're advocating revolution, right? Like, What if they're going on the internet and telling other people, let's rise up? What if they're arguing that the whole US way of life and our entire governmental system is unjust or broken and needs to be torn down? Should that be legal? Doesn't the government have a compelling interest in suppressing this kind of expression? So where should that line be drawn? The next question is, who should draw it? Is this really the proper business of the Supreme Court? Should this be left to the states? Should we reject the whole idea? And then finally, how? Right? So how should the court outline what is too dangerous to allow people to say or write or publish unpunished? For the sake of clarity, I'm going to now introduce the current standard. So the current test, this is the test that supersedes all of the other tests that we're going to discuss in this section, is the Brandenburg test. Right? So this comes from a case called Brandenburg versus Ohio. And I'm just going to give you a brief preview of what the current standard is. So what is incitement? Well, incitement refers to the responsibility that a speaker might hold for encouraging other people to go out and engage in illegal action. It might seem strange to punish a speaker for actions that the speaker themselves are not undertaking. Well, this is one of the questions that we're going to look at in this first line of cases. So this is the question of agency, right? So when I refer to agency, I use this in the philosophical sense, which is to say the responsibility for action, right? So when you decide to, say, get up and walk out in the middle of your class because you've just gotten bored with it, you've exercised your own agency, right? So you are making a decision, following through on it, and you are responsible for making that decision. Now, we see an odd picture of agency in a lot of these early cases, where a speaker is held responsible for inciting others to take actions, right? Or encouraging them or advocating that they take certain actions. So we're going to see this gradually narrowed as time goes on. But as you'll see, in a lot of these early cases, the court used to take a fairly broad view of agency and responsibility. So again, to come back to the Brandenburg test, the Brandenburg test asks whether or not a speaker has incited others to engage in illegal action in such a way that that speaker bears partial responsibility, right? So the speaker might be arrested mid-speech, right? Or stopped from speaking, in which case they might bring a First Amendment defense. Well, if the court finds that they've engaged in incitement, that First Amendment defense is not going to protect them, right? They might still be prosecuted for inciting a riot or disturbing the peace or whatever actual state charge they've actually caught. So according to Brandenburg versus Ohio, incitement can only exist under the following conditions. So one, the language of the speech must show an intent to incite lawless action, right? So the thing that is being encouraged has to actually be illegal, and there have to be features of the language that show some kind of intent. Sometimes this is phrased as being directed at or directed to. Second, the danger posed by that speech has to be imminent, right? So me saying, hey, you know, at some point we should all pick up our torches and pitchforks and rise up in arms against the US government, right? That's not imminent. That's me saying, you know, we should do this. That's advocacy. Now, it's another thing if you are, say, at a political rally and the person on the stage says, you know, we ought to take up arms against that guy standing right there, right? And points at somebody in the audience. This is immediate, right? He's saying we should do it right now. And it's directed to taking lawless action, which would be assault against a present individual. So the danger has to be imminent. There can't be, for instance, incitement in writing, because there's time in between for the people taking in that message to reflect on it, in which case, really the responsibility and agency transfers to them. Finally, the danger has to be likely to occur, right? So if, for instance, Again, you have some firebrand speaker standing on their soapbox saying, let's take up our pitchforks and torches and go overthrow the government, but they're speaking to, say, a crowd of nuns or a crowd of kindergartners. That's not very likely to happen, right? So there have to be some kinds of circumstances that make the danger likely to occur. So these are the current criteria that have to be met for something to be considered incitement. As we'll see in the cases that we'll cover, this hasn't always been the case. So for the rest of this VoiceThread, I'm going to give you just a little preview of the important historical cases. And then in the next VoiceThread, I'm going to discuss those in more detail. I mentioned the 1798 Sedition Act, and this is one of the earliest federal laws passed by the US Congress. Now, 1798, it was early days of the Republic. It was a much more vulnerable and unsteady state. And so we might understand this urge to suppress criticism of the government, right? Also, having just seen a revolution, Americans might have been a bit more wary about allowing advocacy, of resistance to the government, or again, even criticism. So the Sedition Act is kind of notorious because it actually was never overturned by the Supreme Court. In fact, it was never even challenged on First Amendment grounds. Rather, it was allowed to simply expire in 1801. The next major developments that we see in incitement, advocacy, etc., come around World War I. Right? So World War I era laws had a tendency to limit expression. That was critical of the war effort. Now, there were a lot of reasons for this. Again, we'll discuss this in more detail in the next VoiceThread, but I just want to give a little bit of background. So today, often the groups of people who feel that they have had their freedom of speech and expression curtailed are often on the right end of the political spectrum, right? So conservatives often complain that they don't have access to platforms, that they're shouted down, right? That their freedom of speech has been in some way curtailed. Ironically, in the early days of free speech jurisprudence, it was the far left that really kind of drew the most suppression, right? And so the argument for more free speech in that case promoted radical interests, right? Not conservative ones. So during World War I, we'll see a number of radicals trying to criticize the war for various reasons, right? So some of them are ideological. Communists, for instance, didn't want Americans fighting other communists in Europe. Others might have just been pacifists, right? So for instance, Emma Goldman, who's a notorious anarchist, argued against war generally, right? She thought it was an illegitimate activity. So there were a lot of different interests critical of World War I, most of them on the far left. And so we're going to see some figures in these cases who were advocating things that were pretty radical for the time. Many of them are not going to seem very radical to us because today these things are sort of like obviously permitted. But I'm just going to sort of like introduce the laws that form the backdrop to the cases that we're reading in this section. So, one, we have World War I raging. Two, we have this kind of patriotic fervor that's arising, right? So patriotism was running really high during the World War I era. The government did kind of everything they could to promote it. The idea being that, we need to keep national morale high during times of war. And so maybe we don't want people saying that the government is illegitimate. Maybe we don't want them saying that the war is illegitimate. To that end, we see the passage of the Espionage Act of 1917. So, espionage refers to a lot of stuff. Generally, we think of it as spying, right? So it might be relaying information to the enemy. It might be interfering with wartime production, right? So, for instance, work slowdowns in factories that were essential to the war effort might be considered espionage. But it also, this particular Act also reached speech. Specifically, the 1917 Espionage Act prohibited broadly interference with military recruitment and military operations. And in fact, this act in amended form still remains on the books, right? So we still have an Espionage Act. The problematic part of this we see in the Sedition Act of 1918, right? So the Sedition Act specifically forbade, and I quote, disloyal, profane, scurrilous, or abusive language about the US government, the flag, armed forces, or any statements that the American government or its institutions ought to be viewed with contempt, right? So anything that a person might say that may bring the nation, the government, the military, or our national symbols into disrepute. Right? So when you see the word sedition, this should always kind of like raise your First Amendment flags. Sedition specifically refers to expression, right? So sedition is usually spoken, sometimes written, and the term itself is loaded, right? So sedition is disloyal. Sedition is inherently opposed to the national interest. So the Sedition Act of 1918 is going to be one of the acts that we'll see broken in a lot of these key cases. At this point, I want to raise a question. So your book points out that most countries, and the United States is no exception to this, have a tendency to sort of like crack down on civil liberties during times of war. This is exactly what we see with the Espionage Act of 1917 and the Sedition Act of 1918. Is this necessarily so wrong, though? Right? So at a time when the nation is stretched thin, when perhaps our very existence as a country is threatened, isn't it reasonable to expect people to kind of pull together and support the country? So the first question I want to ask is promoting patriotism a vital government interest? Right? Is this one of the proper purposes of government? Promoting patriotism, promoting unity, and even if that means suppressing criticism, especially during times of war, is that reasonable for the government to do? Or alternately, is that completely subversive of democratic interests? Is suppressing criticism one of the things that non-democratic nations do, right? So there are kind of two different ways of looking at this. Which one do you think is right? All right, so I'm going to give you just a very brief overview of a couple of key cases. I do want to say a few words about Eugene Victor Debs. So he is kind of like largely forgotten today, but he was a very famous public figure in the 19th century and early 20th century. So Eugene Victor Debs was a founding member of the IWW, right? So this is the International Workers of the World. This used to be like quite an active national labor union. In the United States nowadays, it's not so much, right? So I personally have met one Wobbly in my lifetime, and she was a tenured astronomy professor at the University of Chicago, right? So she wasn't exactly a downtrodden member of the working class. It was sort of a historical curiosity, I think, that led her to join the IWW. So the IWW, or Wobblies, were to the very, very far left of the political spectrum. They were radical. They were largely socialist and even harbored a number of anarchists and communists. So Eugene Victor Debs was a key figure in the founding and running of the Wobblies, especially in the 19th century. But he was also a national political figure because he ran for president of the United States on the socialist ticket several times, in fact, right? So he ran in 1900, 1904, 1912, and even from prison in 1920. He got a sort of shocking number of votes. Right, so today we would look at this sort of like third-party candidate as maybe kind of a crank or a protest candidate, but that wasn't really the case, right? So the U.S. used to have a fairly active, fairly radical left wing, and it was united behind Eugene Victor Debs. So when Debs versus US comes before the Supreme Court, and we'll discuss this again in more detail in the next voice thread, this was a big deal. We're going to see a kind of give and take with a lot of the tests in this section. And this is because it's kind of a turning point in First Amendment protections for freedom of speech. So at the founding of the nation, the US just kind of used whatever standard already existed in common law. And that standard was the bad tendency test, right? So we'll discuss this in more detail in just a moment, but it's more or less what it sounds like, right? So if expression had a bad tendency to encourage subversion or disloyalty or rebellion, then that expression could be punished or suppressed, right? And so an early case dealing with the bad tendency test is Patterson versus Colorado, which I cite here. But the cases that we're going to look at that are kind of key to the change from the bad tendency test are Schenck and Debs. So out of Schenck and Debs, we see a turn instead to a much narrower standard, right? So bad tendency is really broad. Think of all the things that you yourself have said that might be considered punishable under the bad tendency test. If you've ever complained, about paying your taxes or criticized a government figure, or heaven forbid, suggested that maybe the US shouldn't use its military so much. Those are all sentiments that run afoul of the bad tendency test. The same thing if you, say, go out and talk about Marxism or socialism or anarchism, right? And say like, maybe we should entertain, some of these other systems. Again, punishable, prohibitable under the bad tendency test. So this is just speech that, and I quote, has a tendency to incite or cause illegal activity. So just like encouraging people to engage in illegal activity. Now, this changes with Schenck and Debs, where we see a movement that's largely driven by Justice Oliver Wendell Holmes, who, as you will see, is a really important figure in these early cases. So we see in Schenck and Debs a movement towards a narrower standard, which is the clear and present danger test. So clear and present danger is obviously more specific than bad tendency. So the speech has to show some sort of like immediate danger of causing illegal activity. So this is, again, still a fairly vague standard to modern ears, but it was more protective of expression than the bad tendency test. As you're reading the opinions in this section, I strongly encourage you to take notes on, first, what is the opinion of the court, right? Like, so what's the principle or test that they apply or formulate? But then take a look also at the concurrences and dissents. So in these cases in particular, the concurrences and dissents are really important, again, because we see so much moving back and forth by the court, right? So often we see a test set by the Supreme Court and we think like, okay, great, they've settled something. They've given us the standard, it's going to be stable and hang around for a while. Well, as you'll see with these cases, that's just not how things are, right? So initially we see the bad tendency test that gets displaced by the clear and present danger test. And then in Massa's Publishing Company versus Patton, we see a federal judge who is not a Supreme Court justice, right? This is just Judge Learned Hand, articulate an even more narrow test than the clear and present danger test. And we see the court kind of considering this because this particular judge, who I'll say more about later, was very influential. But then along comes Abrams, right? And so we'll see this turn at the Abrams case. So again, look at the concurrences, look at the dissents, because we're going to see a lot of foreshadowing in the concurrences and dissents of where the court ultimately goes in the future. Abrams is a key case. Justice Oliver Wendell Holmes changes his mind in Abrams. And it's not entirely clear why that is, right? So we We think it might have had something to do with his law clerks. It might have been the influence of Louis Brandeis. We don't know. So we see this turn in Abrams. But then we also see, Gitlow versus New York and Whitney versus California in the 1920s, where it looks like we're moving back toward the bad tendency test again. So as we go through these cases, it's really tempting to always see Supreme Court doctrine as evolving in this kind of straight line, right? It's easy to look back and think, yes, it was always heading in this direction. But in fact, there's often a lot of bouncing back and forth, right? The court says one thing and then takes it back. What was a dissent in an earlier case has now been adopted by the majority. And so you're going to see a lot of this messiness and inconsistency that I keep talking about, especially in these cases. But as you're looking at this, look at the reasons that are being given, right? So there is a sort of general direction the court is moving in their reasoning, even if it takes them a few cases to get there. I'm going to close this voicethread by discussing just a couple of key ideas. So like I said, some of the terms that emerge in these cases you've probably heard before, and you probably didn't know they come from these old World War I era Supreme Court cases, but there they are. So for instance, the example of shouting fire in a crowded theater comes from a case in this era, right? And in fact, it's Holmes. And so as my First Amendment teacher liked to stress when I was an undergraduate, the problem isn't necessarily shouting fire in a crowded theater, it's falsely shouting fire in a crowded theater. Right, so you've probably heard this before, and you've probably also heard this term, the marketplace of ideas. Well, the marketplace of ideas comes from Justice Oliver Wendell Holmes' dissent in the Abrams case. So what does Holmes mean by the marketplace of ideas? Well, it's good to get this down because you're going to see it used a lot in free speech cases. The marketplace of ideas metaphor simply means that we should provide an interference-free space for ideas to be expressed with the expectation that citizens are competent to promote the ideas that are better, more true, that are closer to the public good. And just as they're competent to promote the public good, citizens are also competent to reject noxious ideas, right? So ideas that are discriminatory or false, or the term Holmes might use is evil, right? So bad ideas, Holmes trusts, will be rejected by the public. And so Holmes says, you just have to kind of let everything be out there and then trust the citizenry to sort through it. Now, Holmes actually didn't completely come up with this idea by himself. He was an avid reader of philosophy. He was very much influenced by pragmatism, right? So the American pragmatists, including Peirce and James, but he was also influenced by the English utilitarians, and specifically John Stuart Mill. So in On Liberty, Mill uses this very idea of the marketplace of ideas, right? So Mill makes the same point, which is to say, if we allow a free space for expression, the cream will rise to the top and the garbage will sink to the bottom. Do you think this is a good metaphor? Is it useful? Right, so should we still use this as a reason for, say, not prohibiting hate speech, right? Or allowing people to publish manifestos claiming that, say, the earth is flat, or that we need to be concerned about conspiracies by lizard people. Does the marketplace of ideas actually work, right? Do these bad ideas, get weeded out? Do the good ideas get advanced? Or, is Holmes putting too much faith in democratic citizens? Right, so those are the first set of questions I'd like you to consider. The second is, okay, well, what about the market, right, as a metaphor for the space where public deliberation takes place, right? So there are things that markets do well, and there are things that markets don't do well. So just kind of reflect on that. do you think that the market is the right metaphor, right? Um, because markets are really good at allocating things efficiently, but is that actually what we want from expression, right? Is it really about allocation? Or is this maybe an inapt metaphor, right? Is this the wrong metaphor to use for the public sort of like forum of deliberation? All right, so I encourage you to comment on all of these things on the discussion board, and judging by the last set of posts, I expect a fairly lively conversation, and I look forward to reading it.